Going to go ahead and move on to Assembly Bill 202. This bill revises provisions governing the electronic communication of devices in certain
either a
healthcare
camera
facilities.
or a recording device, which could vary from a Amazon Alexa device that they can communicate, such as, or an iPad for FaceTime and things like that, or any other type of recording device, so the family and who they designate, and they would have to designate in writing, would be able to access. You have to remember that those in a nursing home, that room becomes their residence. That is their house. You may hear some opposition that it violates a wiretapping law. It does not. Wiretapping has to do with cell phone communications or telephone communications, and without the party's consent. Here, the person that lives in the room is giving consent. In addition, the nursing home has the right to put up a sign in the door that says, hey, there is a recording device here.
Page 5, and where the roommate can waive the right to privacy, even if they, an agreement by the roommate or the representative of the roommate to expect otherwise, and that means privacy. And so I worry about that legality and placing the roommate in a position that they feel bad, or do they even have the understanding that this is going on? So just a little bit, is there any protection there for the roommate's privacy? I have a security on my own home, and I can look at right now and look at my house and see what's going on. That's different than a communication device. And so I'm wondering, are you looking at this as something that records the data? Because you use the term record, and then who would keep that, and the legality and the privacy issues with that?
The only person that would have the access to that data is the patient themselves, or if they authorize somebody specifically in writing. So it's there because they're the only ones being recorded. It's their room. They would be the only one to be able to access that data. So it wouldn't be available, for example, for us to watch here. There wouldn't be a YouTube channel or anything like that. So the data would stay private if they chose to record anything. Many would not choose to record. It gives them that option, and it places no limitations on that.
Oh, okay. So I was just going to interject unless if Senator Titus has any follow-up questions as well after my question. So how do you respond to the question of immunity for residential groups? I know that in the opposition letter, there was a request that this legislation should give nursing facilities explicit immunity for the use or misuse of recordings. And so if there is a recording that is leaked online, et cetera, and there's an employee that
For example, some families are just
was
concerned about the safety and welfare of their loved ones. And they go, hey, I would feel more comfortable, and the patient, the loved one, would feel more comfortable if there was a device, whether it records, whether it doesn't record, that somebody could peek in and see.
I know that we'll have, and my colleagues will probably have questions as to the recording versus monitoring, and so I'll let them ask those questions. But that was just my main worry. And I know that this is one way that you can look at, and I know that I just want to make it clear that there are also other ways that you can detect abuse with patients. Bed sores is the easiest one, bruises, et cetera. And so I just wanted to put that out there. But Senator Titus.
Thank you, Chair, for the
concerned about the recording devices. So you have medical personnel that's coming in and performing some very delicate, intimate tasks that are going to be captured on a camera. Sometimes a recording only tells part of the story of what's going on. I know that there are some statutes that you have to get permission to be recorded. So would the employees of these homes have to sign some kind of a release saying that they know that they're being recorded and they have to agree to be recorded in order to be providing treatment for the prospective patient?
Thank you, Senator Stone. Jamie Cogburn, for the record. The short answer is, as to the employees, no, they're not required to have a release. As part of, they work there. Frankly, at most facilities, there's already cameras in the open hallways, considering the public area. This would be in the private room. In the bill, and I forget the exact number, I think it's section 13, it does allow them to place a sign to let them know that there is a recording device.
I know in looking in some places like Texas, this has been a law for like 20 years. And I'm just curious right now. I have an Alexa in my like office here. I use it to communicate with my kids, but I know it's constantly recording because just like my phone is recording me, it's recording me right now because if I start talking about like something, it's going to pop up on my phone like minutes later in all the advertising. So I know that they're always listening to us, and that's the way these devices work. If I was to say Siri loud enough, I bet half of our phones might respond. So how is this different than under current law, the way we have it right now? Can people that are in their homes in these residential facilities not have a cell phone, not have an Alexa, not have any of those devices?
Thank you. Jamie Cogburn for the record. Senator Nguyen, that is an excellent question. Actually, they can. It's that many facilities do not
For the
allow.
record, my name is Brett Salmon with the Nevada Healthcare Association. We represent nursing facilities and assisted living facilities throughout the state. We are currently in opposition to the legislation based on Nevada case law that went before the Nevada Supreme Court in 1998, that we do have a wiretap issue, and that liability shifts to us. We believe that that's not addressed in the bill. Electronic devices that would be in these facilities that would record conversations require explicit consent under that case law, and as a result, we believe that shifts liability to us. Where the language in the bill in Section 13 says that it would prohibit a facility employee from refusing to enter a room where the devices are being used. We believe that we can manage our employees. If there is an employee that has a particular reason why they don't want to be recorded, we believe we can handle that and we can accommodate that, and we'll just not have them go to that particular room. And we think that having an amendment that would address that would be a pretty easy impacts physicians, the hospice workers, rehab workers, transportation workers, and other people that might be recorded. And then circling back to that wiretap issue that we're concerned about, because there wouldn't be explicit consent for those people to be recorded, we believe that liability lands on us. Addressed in the legislation, then obviously we don't have a problem. And per the questions about video monitoring as opposed to recording, that's a different thing under Nevada law. Video monitoring is not an issue under the wiretap law. Where it's recorded, then it comes into conflict with that particular Nevada case. And so that's
you had mentioned something. Frankly, I disagree with your assessment of a 1998 case,
Okay.
Pre-Alexa, pre-cell phones, pre-iPhones, pre-anything, pre the birth of our chair. No, very close, right? Very close. I just, the liability issues, like how do you deal with that with other like personal effects of like a person?
Brett Salmon for the record. I'm not sure I understand your question. Can you help me understand that better as it pertains to people falling? Or
I guess I just don't understand what the objection is to having people be able to record or have these devices that are able to communicate. And I'm not sure where you see the line where someone can have an Alexa, or can they never have a situation where they have an Alexa because that device is I guess you always would recording. legislatively through like a piece of legislation like this. I mean, if Texas has had like a similar statute in place for 20 years, they obviously sought to put it in statute, and if there was case law that overturned that, that would happen. So wouldn't this fix your your case law issue that you have from that 1998 wiretapping like interpretation?
Clarification from our legal
Brett
counsel
Salmon.
regarding the case law, so please proceed.
Yes, Eric Robbins, LCB Legal for the record. So, our, I guess, opinion on this is that there would be no conflict with wiretapping laws. What this bill is saying is the nursing facility has to consent as a condition of operation in this state.
Senator Titus?
No,
And
I don't have a question. I have a comment about that. We were just chatting here that one of my concerns about the bill is the liability issue for employees, people coming in, the cleaning women, all that, and recording them. And on Section 13, it says that they may post notice. I mean, I don't believe in you're secretly recording people. That I have an issue. So, I mean, anyway, my point is that I worry about the liability and employees' privacy, other roommates' privacy. So if this was to happen in facility, I think it has to be posted that there's monitoring in place.
As a result,
Not may.
We believe that shifts liability to us, and that liability shifts to us. We believe that that's not. For the record, I'm not sure I understand your question. Can you help me understand that better as it pertains to people falling. Or
I guess I just don't understand what the objection is to having people be able to record or have these devices that are able to communicate. And I'm not sure where you see the line where someone can have an Alexa, or can they never have a situation where they have an Alexa, because that device is always recording. It is always on. Your cell phone is always recording as well as it is always on. Like, do you not allow those kind of telecommunication? Like, do we only have landlines in these facilities?